Thank you, Katarzyna. Thank you, Professor Czubik, the head of our team. Thank you, organizers, Professor. I will try to be short and to say a few words about the expansion of the types of subjects entitled to diplomatic and consular activity under Polish law. The primary normative act regulating diplomatic and consular activities in Poland is the Act of June 25, 2015, Consular Law. The purpose of this short presentation, however, is to familiarize the reader or the listeners with the legal framework that allows for the involvement in diplomatic and consular services of individuals other than those traditionally associated with these roles, such as ambassadors or career consuls. Additionally, it aims to highlight the need for changes to the legal framework in Poland in this area through proposals de lege ferenda. The first group of individuals who, despite not being professionally affiliated with the diplomatic and consular service, have been endowed with significant competences traditionally associated with career consuls are, of course, honorary consuls. The institution of the honorary consul is not uniquely Polish. It originates from ancient Greece. The precursors of today's honorary consuls were the proxenoi, citizens of another polis who received honorary title from a polis along with the obligation to care for the citizens of the granting polis and represent its interest in the polis where they resided. Today, this institution holds a place in the legal systems and practices of most countries around the world, significantly complementing and enhancing the activities carried out by professional consul services in the interests of both the sending state and its citizens, as well as the receiving state. According to Article 120 of Consular Law, an honorary consul of the Republic of Poland, hereinafter referred to as the honorary consul, may be a Polish citizen or a foreigner, permanently residing in the receiving state, possessing high authority and ensuring actions in accordance with the interests of the Republic of Poland. Furthermore, according to Article 121 of Consular Law, the following classes of honorary consuls are established: honorary general consul, honorary vice consul, and honorary consular agent. The scope of duties for honorary consuls is broad under Polish law. According to Article 129 of Consular Law, an honorary consul supports the consul to whom they report in the following areas: protecting the rights and interests of the Republic of Poland and its citizens in the receiving state, fostering friendly relations and cooperation between the Republic of Poland and the receiving state, strengthening ties between the Republic of Poland and Polish citizens, individuals of Polish origin, and those declaring affiliation with the Polish nation residing in the receiving state, for developing and deepening economic, scientific, technical, and cultural cooperation between the Republic of Poland and the receiving state, as well as promoting the Polish economy, science, culture, and language. And fifth obligation, providing consular assistance. Moreover, under Article 134 of Consular Law, the Polish Minister of Foreign Affairs may, upon request, authorize an honorary consul to perform specific notarial acts. This include, upon the request of a Polish citizen or a Polish public administration authority, preparing and certifying excerpts, copies, extracts, and duplicates of documents, certifying the authenticity of signatures and handmarks, confirming the date of document presentation or the fact that a person is alive or at a specific location. While the scope of activities defined in Article 129 aligns with the global standards for honorary consul, it's quite obvious. Delegating even a limited range of notarial functions to honorary consul has raised justified concerns. The Polish notary system and the role of a Polish notary are firmly grounded in the civil law notarial system. This system emphasizes highly specialized, independent, and licensed public officials who safeguard legal certainty in transactions, unlike the Anglo-Saxon notary public model, which primarily involves document certification and does not necessarily require legal education. For instance, in Poland, all real estate transactions must, under penalty of invalidity, be conducted through notaries preparing notarial deeds. While honorary consuls of the Republic of Poland cannot prepare notarial deeds, even career consul may prepare them only after receiving prior approval of the draft and authorization from the Minister of Justice as stipulated in Article 28 of Consular law. Assigning notarial functions to honorary consuls poses risk due to both potential incompetence, as they are not required to have legal qualifications or extensive knowledge of the Polish legal system, particularly if they are citizens of the receiving state. And the second, dishonesty. For example, issues such as certifying signatures or confirming a person's presence at a given time can have serious implications in areas like inheritance law. It's quite obvious for lawyers and for us judges. Professor Piebiak is the expert in this area. So the introduction of this widely criticized provision in 2015 sparked intense debate in both professional and popular media, as well as in Polish parliament. Concerns included not only the risk outlined above, but also the potential lack of impartiality among honorary consuls, many of whom might exploit these powers for personal business gains rather than ensuring legality and maintaining the prestige of the sending state. Ultimately, however, the provision was enacted. From a legislative perspective, it is strongly recommended, in my opinion, that this regulation should be repealed to mitigate associated risk and uphold the integrities of Poland's legal and diplomatic standards. Notarial deeds in Poland must be executed through notaries, ensuring compliance under penalty of nullity. Honorary consuls of the Republic of Poland are not authorized to prepare notarial deeds. These concerns should be abolished. This idea leads me to this de lege ferenda proposal to repeal it. According to information currently available on the official website of the Polish government, Poland has appointed approximately 250 honorary consul. This indicates that the institution is gaining popularity as the number of honorary consuls has doubled over the last 20 years, almost doubled, increasing from 141 active honorary consuls in 2005. The next group I would like to talk about, who are not formal members of the diplomatic and consular service, and should play an essential role in economic diplomacy, involves supporting Poland's economic development as a sending state. Is carried out by employees of specialized agencies situated within diplomatic and consular missions. Traditionally in Poland, as in many other countries, this role was fulfilled by economic commercial officers, where at least some staff, including commercial attaché, held diplomatic ranks. Dissatisfaction with the often lackluster outcomes of the economic commercial divisions inherited from communist Polish People Republic led to a system overhaul. Consequently, in 2017, on the Act of July 7th, on the implementation of tasks in promoting the Polish economy by Polish Investment and Trade Agency, has been in force. Under this act, the agency task referred to in Article 2 may be carried out through foreign trade offices established and managed by the agency in a legal and organizational form adapted to the legal and economic conditions of the place of establishment, including capital companies. To date, these offices have been established in 57 countries, with multiple offices in some the biggest states in the world, such as the United States. While the model has some clear advantages, this model, which exists now, such as operating under the framework of a joint stock company, which is theoretically less susceptible to the influence of current political conditions and focused on efficiently achieving its objective, it also has a significant drawback. The lack of direct and visible connection to the sending state, which is typically ensured by diplomatic status, and integration within the network of diplomatic and consular posts, poses some serious challenges. Much depends on the specific conditions of the receiving states, but it is evident that this detachment from official state services hampers the achievement of the intended goals in many cultural and political contexts. For instance, in markets where the economy is closely tied to a political power, and we know that there are some economies and markets in the world like this separation complicates the process. In simple terms, in many markets, the absence of direct diplomatic support either precludes or severely hinders even the most competitive enterprises from entering and operating effectively. You can say Arab countries, African countries, Asian countries. If there is no connection with official diplomacy, you are not going to have a success. The efforts of even the most specialized agencies in such markets are insufficient as they lack the tools necessary to guarantee economic success under these circumstances. An additional issue too is that the numerous international agreements regulating economic cooperation between the Republic of Poland and other states include references to economic commercial divisions as entities acting on behalf of Poland as contact point with the administration of the receiving state. These agreements have not been renegotiated to replace with agency offices, making it challenging and in some cases impossible to utilize the opportunities this agreement provides. It is difficult to assume that the agency offices as commercial entities could be considered successor of the formerly dissolved economic diplomacy units in the Republic of Poland before 2017. This raises the question of whether the 2017 reform of this underperforming area of Poland's foreign operations was the right approach and whether it needs to be redefined. And the last final group of I want to talk here. The final group to be examined in this study includes various specialists who could potentially assist diplomatic and consular missions in addressing specific problems faced in certain countries where the classical personnel of Polish diplomatic and consular posts may find the challenges too overwhelming. These specialists could effectively support the missions in protecting the interests of the Republic of Poland and its citizens. Article 7, Act of 2021 on the Foreign Service states, whenever the Act refers to a delegated employee, it means a person designated by a minister other when the one responsible for foreign affairs or the head of a public finance sector unit performing auxiliary or service duties in a foreign post as specified by the designating authority. To elaborate this issue, I will focus on one of the most serious challenges hindering the functioning of Polish citizens abroad. A problem the author encountered firsthand while serving as an Undersecretary of State in Polish Ministry of Justice from 2015 to 2019, responsible for common judiciary and the Ministry international relations. This challenge was, and unfortunately still is, the prevalence of numerous cross-border disputes concerning the residence and custody of children of Polish citizens living abroad. These disputes often arise between the parents and are exacerbated by the practices of foreign institutions obligated to assist families. Professor Piebiak mentioned Barnevernet, Norwegian, Jugendamt in Germany, or the special, I don't remember the name, special agency in United Kingdom. These institutions sometimes abuse their powers, removing children from the custody of their parents, often Polish citizens, and placing them in specialized state institutions or foster families from entirely different cultural backgrounds. We had many cases, for example, in United Kingdom, where the small child was taken from the Polish family and taken to the Muslim family, traditional Orthodox Muslims. Completely different, different people, completely different cultural background. In such cases, court disputes adjudicated both by Polish family courts and by foreign courts, there are sometimes contradictory outcomes. Additionally, these cases generate media attention. Also, diplomatic tensions arise in these cases because not all the countries respect international legal obligations to the same extent, including those stemming from the United Nations Convention on the Rights of the Child, adopted by General Assembly in 2089 in New York. Article 10 of the convention states, a child whose parents reside in different countries shall have the right to maintain on a regular basis, except under exceptional circumstances, personal relations and direct contacts with both parents. To this end, and in accordance with the obligation of state parties under Article 9, states parties shall respect the right of the child and his or her parents to leave any country, including their own, and to enter their own country. The right to leave any country shall be subject only by such restrictions as are prescribed by law and are necessary to protect national security, public order, public health or morals, or the right and freedoms of others, and are consistent with the other rights recognized in the present convention. Cases of this nature, due to their sensitive nature, I'm trying to be short, should be handled not only in courts but also by diplomatic and consular representatives with the utmost care, discretion, and use of specialized knowledge and experience, capabilities that professional diplomats often lack. Between 2015 and 2019, an idea emerged to use the institution of a delegated employee to appoint family court judges to Polish missions in countries where such problems were the most prevalent. And for example, Norway, Germany, and the United Kingdom. These judges would bring not only their adjudicatory experience, but also their administrative expertise gained from working within the Ministry of Justice. Delegated judges in Ministry of Justice often coordinate activities related to such issues within the ministry. Sorry, it is too long, so I have to skip One moment. Okay. The expectations for the effectiveness of tasks assigned to such judges were high. There are described competencies and status, which were highly valued within the Ministry of Justice and its related agencies, would also significantly strengthen relations with foreign state authorities. Unfortunately, it must be regrettably noted that such delegations of the family court judges to Polish missions abroad have never occurred to this date. Officially, the reason cited for this lack of implementation, because we changed the law in 2017, was alleged legislative shortcomings. It was argued that the delegating a judge to the Ministry of Foreign Affairs is not equivalent to delegating a judge to perform tasks abroad within the network of diplomatic and consular missions, and thus the regulation would need to be amended for another time to enable this. Unofficially, however, the situation arose because the Minister of Foreign Affairs never submitted a request to the Minister of Justice for such delegation, because there must be a request from Minister of Foreign Affairs and acceptance from Minister of Justice responsible for work of Polish judiciary. The reluctance was attributed to a career diplomats who were expected to benefit from the assistance of such delegate judges, but opposed this initiative. As a result, this institution remained unused, preventing the practical evaluation of the assumptions that led to its introduction into the Polish legal system. Thank you very much.